let's see. I want to revisit the term of an affidavit. What is an affidavit? Okay, most of y'all know what an affidavit is already, but I feel like I have to make these videos sometimes so we can they're sort of like refreshers or sort of like refreshers or reminders of what affidavits are and how powerful they are, and who can actually do an affidavit. Okay, who can actually do an affidavit? That's one of the reasons I wanted to make this video. I'm gonna make these letters big this time, because I'm only gonna be using this dictionary. This is the Black's Law Dictionary, 1933 version. Third edition. Okay, I'm gonna start with reading this here, and I'm gonna kind of take off from there. I'm gonna flow with it. I'm gonna try to make it short and sweet because I gotta go hit the gym. I can't sit here in the house like this. I gotta go get it popping. Okay. An affidavit is a written or printed declaration or statement of facts made voluntarily and confirmed by an oath or affirmation of the party making it. So if you create an affidavit, it has to be under oath or affirmation. Okay, if it's not done under oath or affirmation, some people don't like to swear, so they don't like to say I swear under penalty of perjury. Some people they prefer to say I affirm under penalty of perjury. So it still takes the same full effect. Okay, that's in case you know. That's for people who have religious beliefs that they don't want to violate, yet they want to exercise this right to do an affidavit. Okay, taken before an officer having authority to administer such oath. A notary will be that. They are authorized to administer oaths. You can do that with a judge. You can do that, a clerk, a county clerk. Those people, you can do that. There are different officers who are authorized to administer such an oath for an affidavit. Even when you're getting your passport, you are standing before an officer who's authorized to administer an oath that you're doing, because you notice on the back of a passport you even see where you have to sign it. There's a spot where you actually have it says you're swearing to the facts that you wrote on that document. So that passport application is also in affidavit form because you're swearing under penalty of perjury. You're affirming or you're swearing or affirming to the facts on that you wrote down. Okay. And this is case law right here. Let's see. Cox versus Stern. Let's see. I'm going to read some of these things that it says about affidavit. And I have a point as to why I'm saying this, okay? Because a lot of times I've been speaking about the presumption of death for the last few months, and I've said all I can say about it. I think I made my point clear on my channel about the presumption of death and how all 50 states and all companies do this. They have a presumption of death. Okay, so I thought I'd kind of make this video about an affidavit. And I'm gonna finish reading. I'll get to my point as to why I'm talking about affidavits. A statement or declaration reduced to writing and sworn to or affirmed. That's what I said earlier. Sworn to or affirmed before some officer who has authority to administer an oath or an affirmation. Okay, they pretty much repeated themselves, but in different words, different. This is another, let's say, quoted and approved in Shelton versus Berry. So these are different case laws that are actually telling you what an affidavit is. An affidavit is written declaration under oath made without notice to the adverse party. An affidavit is an oath in writing sworn before and attested by him who has authority to administer the same. Not versus Duclos or Duclos, if I'm saying it right. An affidavit is always taken ex parte, and in this respect, it is distinguished from a deposition, a matter of which is elicited by questions and which affords an opportunity for cross-examination. Okay, Say, but the word affidavits is sometimes used to exclude depositions. You know, a deposition is basically when somebody's in question and they're sitting down and they're everything they're saying, they're swearing everything that their testimony, their answers to the questions that are being asked are given. The answers are sworn or affirmed to be the truth of the matter, to the best of their knowledge. But an affidavit does not require questioning. That's what they mean by it, is which is elicited by questions. You know, so you don't have to be. It don't have to be in question form. You just basically stating your testimony and you're swearing what you said is true. Affidavits are of two kinds. Those which are served as evidence to advise the court in the decision of some preliminary issue or determination of some. Come on back up here. Substantial right, and those such merely serve to invoke the judicial power. That's Worthing versus State. Now, I wanted to. The reason why I'm talking about affidavits is because when you're given a declaration is, you notice in this definition it kept saying, using the word declaration. It's a written or printed declaration or statement. Declaration or statement. See? Declaration. It uses that word kind of loosely. Let's see. Kept on saying it. Let's see. I noticed it was using that word, quite a bit. Let me see. Let me back out of this for a second and get to my other point. Okay. Okay. Let's see. A declaration is an official statement or proclamation, such as an affidavit. If a person making a declaration called a declarant lies in it, the declarant may be guilty of perjury. This is what makes them so of an affidavit as admissible evidence, because you're putting your neck on the line when you putting your declaration or your statement under oath as an affidavit, and you put it on the oath. You submit it to the courts as your evidence to prove what it is that you're saying, to the facts of what actually happened in whatever's going on in the case. You wouldn't have put your neck on the line, because if you're found to be lying, say if they lie in it, the declarant can be guilty of perjury, and you don't want to be. And so if you file that into a court case, they can actually, and they found that you lied, then that same document can be used against you in a perjury case. You can be charged with perjury, generally, which means they're saying you generally a witness. A witness in a trial commits perjury when they knowingly and intentionally lie about the material issue. The precise definition of this crime varies by jurisdiction, but SC federal law prohibits perjury, 18 U.S.C. 1621, as well as other false declarations before federal court. Okay, so. Who can actually lie in a declaration? Who can actually do that? Who can tell the truth? Only a living man can do that. A legal fiction cannot lie. A legal fiction cannot declare, cannot make a declaration. Okay? A legal fiction can't do that. Therefore, a legal fiction cannot create an affidavit. With that being said, when you're filing an affidavit in your court case, you're being served. The living man will serve a summons. You were given a summons. A summons can only, let me see what it's going to say about it. I know it's probably going to, we already know what it's going to say legally, but we know it's going to say legally. Soon required to appear in court. We talked about that already. A summons is a form prepared by the plaintiff and issued by a court that informs the defendant that they are being sued. Keep in mind, the plaintiff and the defendant are the straw man. Okay, they keep everything in. All crimes are commercial. Remember, keyword is commercial, and only entities exist in the commercial world. Okay, a plaintiff and a defendant are both entities. Then that's why the names are in all caps. Those are entities. But you, as a living man, see, that's why the entity is being summoned. Okay, they're giving it to you because you're the responsible party of that entity. That's why they gave it to you. That's why you were served the summons. Of course, they can't summons the dead. I mean, they can't summons the living. They can only summons the dead. Okay, but they're summoning the plaintiff. Okay, now chain of command. Starting off, you have to, in order to get to the plaintiff, you have to go to the one who's in charge of the plaintiff. This straw man, Michael Roseman. This straw man, Michael Roseman, or if the Michael Roseman is a defendant, has to get served. And the only way you can't serve you can't serve the straw man, because the straw man can't do nothing. The straw man does not exist in the real world, in the land of the living. So the living has to receive that in order to conduct business. In order for someone to conduct business with that name, they have to serve the responsible party, the living man who is responsible for that name. Okay? This is why I'm hoping I'm getting some wheels to turn so y'all can understand where I'm going with this. So when they're trying, keep in mind, all crimes are commercial. Anytime they got you in court, whether it's going to be civil, which means it's dealing with somebody who has something to do with contract, maybe it's a contract that was being breached, or it's criminal, meaning there's an injured party, as we call it, a corporate delicti, or it's a corpus delicti. Sorry about that, corpus delicti, which is Latin for the body, basically it's an injured body or whatever. I ain't gonna go through that. I'm gonna stay with one. I'm gonna look it up so I can, but never mind. Y'all get it. Meaning there's an injured party. That's what a criminal case is supposed to be about. So when the living man receives the summons, is really the commercial or them somebody in their commercial. Keyword is commercial. Everything that's commercial is in all caps. Okay. Okay, state of Georgia, a representative from state of Georgia, a state of Alabama, a state of Washington, state of Florida, and so forth. All those are representatives. Anybody who serves you, that they're in their commercial capacity. So they serve summons. Everybody in their commercial capacity, they operate in their fictitious capacity. So they're serving your summons. Okay, they're serving it to you because you are responsible for that name, which also only exists in the commercial world. So your job, if your name is a defendant in a court case, and somebody in their commercial capacity issues you a summons, gives you a summons, they're summoning that name because they're trying to offer to do, they're trying to invite you to do business with them with that name in a court case. Your job as the living, let's just say if you're being accused of something and they can only only punish you financially or whatever, however they're trying to punish you, they have to do it through the name. Okay, but so your job, that's the reason why you would be using an answer, a verified answer. Remember, I told y'all in my previous videos, your answer must be verified, which means it should be in affidavit form. Remember, verified. Verification, I'll do that one. There we go, we'll do that one. Verification is a declaration swearing that statements made in the document are true. Depending on the jurisdiction, verifications are either made under oath or in the presence of a notary public or similarly authorized person. Verifications are traditionally attached to the end of all pleadings that are required to be sworn, also called affidavit of verification. Okay, now, and that's also in that Black's Law Dictionary. I started to read that, but I didn't. But bottom line is, back to the summons. Keep in mind, only a living man can do this. Only a living man, the straw man can't do this. That's why it's vital for you to verify an answer. Put a verified answer in your court case, because not for one, you're rebutting any presumption that you're operating as a fiction, as the straw man, which is the trust, the Sesticate trust. Okay, which you're the one that authorized to do business with it, but they are also trustees. The public officials are trustees. So if you're going in there operating as this, they're going to be operating their trustee capacity, and basically they're going to be trying to operate as if they're in charge to control to control that defendant or that plaintiff. They're not going to be operating their fiduciary capacity for your benefit. They're going to do it based in the best interest of the state for the most part. But because we know how they operate there. But bottom line is, you're supposed to protect this thing by giving a verified answer when someone bringing and even if your name is the plaintiff, your complaint should be verified as well. It needs to be verified. That it not only does it rebuts the presumption of death, meaning you're not operating as a fiction, and you are alive. Okay, so now you're neither one of y'all, if y'all both got verified, the plaintiff and the defendant both have verified answer. Now they're going with the evidence that's presented in the court case. What evidence do we have that we're presenting in court? When it comes to trying to get your remedy in court. But the way you protect that's the best. The only way. The way you're doing your verified answer, as you see. Verification right there, that's the same notice. It's the same description as an affidavit. Notice what it says: verification. It has a declaration in there, swearing that the statement is true. That's the same thing you just said about an affidavit. And it says it has to be done by someone sworn in the presence of somebody's authorized to administer an oath. Y'all saw the exact same thing inside the affidavit definition. So, see, also called affidavit of verification. But bottom line is, your answer needs to be verified. Okay. So, and only living men can do these things. Only living men and women can declare something, can swear something. And let's see. And most of the time, keep in mind who you're swearing to. If you are swearing, you're swearing before God or your creator, whatever, religion. If you subscribe to a religion, then you're swearing before your God. That's what living men and women do. Okay. And if you're not one of those people who are religious, or you don't believe in God, then you're gonna do an affirmation instead of swearing. You'll affirm, just like an affidavit says. But only living men and women can do that. Okay, this is why it's imperative. That's the move. You have to make sure that you file a verified answer in any type of court case that you are involved with, and it's going to be your testimony. The truth, the whole truth, and nothing but the truth. Just like they say, so help you God. Only a living man can do that. That rebuts the presumption of death. Okay, that rebuts any presumption of death. And I'm not going to read this whole thing right here. It's a small little thing, but it's only talking about a summons. I guess I can read it since it's short. But let me see. Say maybe served by a sheriff or authorized person such as a process server. Say in context in civil cases, this is from Nebraska. Explains that a summons is an instrument used to provide notice to a party of a civil proceeding of the opportunity to appear and be heard. Keyword appear. Remember, go back and look at my video where I titled it appearance. What is an appearance or something like that. But you look at that video, it shows you that you physically don't have to be in there. Okay, you can file an answer in there. An appearance is not limited to you physically going in there acting like the straw man. Okay, because if you go, when you file it into your court case, you file your answer, a verified answer into the court case. You don't have to be there. Okay, now go back and look at my videos on that. So we're not going to turn that into change the topic on this video here. Go watch the video about appearance. A summons informs the defendant that they have a certain number of days to respond to the lawsuit or appear in court. See, respond or appear in court. you know what I'm saying? They're going to use the word appear right there anyway, but they want you to make a physical appearance. When they're using layman's terms when they say physical appearance. They know damn well you ain't got no business in that motherfucker acting like you the straw man. But that's neither here or there. It depends on what kind of court case it is too. So it depends on what kind of court case it is, what jurisdiction it is. So I don't want to kind of confuse y'all with that part. But bottom line is you gotta respond or you need to go there. I keep on really kind of targeting child support type cases because that's what I'm dealing with, and that's what most people deal with. I'm dealing with a custody type case, but most people are dealing with child support, and that's mainly what draws people to this channel. People who dealing with trying to deal with their offspring. So that's mainly what I'm talking about here. Okay, in a criminal context. In the context of criminal cases, that could be traffic case, or you got a felony going on, or some type of injury party type case. A summons can be served on a defendant facing minor criminal charges and used as an alternative to an arrest warrant. So let's see. This case from Missouri explains that a summons is more or less a notice or an invitation. See, an invitation to the defendant. That means you can go there or you not go there. Somebody invites you, you can go to the party, or you don't have to go to the party. It's up to you to physically go there or not. It's an invitation to a defendant, straw man, to come to court at a certain time and answer to a certain charge, so that he may not be subject to inconvenience and embarrassment of an arrest. Okay, here's a charge. Just how to see right here. I'm gonna read this anyway. Criminal case charge is a formal accusation of a criminal activity. Okay, prosecuting attorney decides on the charges after reviewing the police reports, witness statements, and any other evidence of wrongdoing. Formal charges are announced at an arrested person's arraignment. This is something I actually dealt with. This is a little off the record. I'm gonna wind this down, but I'm gonna end this after this here. I just had to. I dealt with this one time where I was standing there listening to when I was dealing with a traffic case. I think I didn't have insurance or something. I didn't have proof of insurance. I had insurance, but didn't have proof of it. Back then, they couldn't tell whatever. They couldn't tell. But anyway, I was in court, and this attorney. This prosecuting attorney. He was the one that was reading. He was reading some document. Basically, he was just reading what happened, so-called happened that night. And keep in mind, he wasn't there. Now that I know what I know now, I would strike him from the whole thing because he has no firsthand knowledge of any damn thing, and he ain't gonna get no verified answer anyway. You see right here, say after reviewing the police reports, say he decides the charges after reviewing police reports, okay, and witness statements and any other evidence of wrongdoing. That's all he doing. He basically he's a third party intervener. He has no first-hand knowledge. He's just reading what they said. Okay, statements, witness statements, evidence of wrongdoing, of any wrongdoing. If there's any, if there's a traffic case, it probably won't be any. Depending on what it is. Like, say my situation, that's all mine was about some insurance. He had no evidence. He wasn't there. He wasn't there. Bottom line is, he was disqualified to even be in there reading any damn thing, trying to decide, keyword, decide a charge for any damn thing. Okay. So it's hearsay. Anything he's saying is hearsay because he reading something that he have no first-hand knowledge of. You know what I'm saying? So he was not eyewitness of anything. Okay? And so he was not willing to do, he was in his commercial capacity too, so keep that in mind. He was a prosecuting attorney, so he's in his commercial capacity. He's at work. Okay? So me as a man could have easily just like filed an affidavit in that court case, or objected right there in court, or had make sure I had an affidavit filed in that thing, rebutting anything he had to say. You know, anyway, I really could have got this shit shut down because he had no first-hand knowledge. But I didn't know that then. I didn't know that back then. Okay. In jury trials, a charge is the instruction given by A charge is the instruction given by a judge to a jury regarding the law, its application, and the weighing evidence. A charge may be a financial burden or an encumbrance, lien or claim. Okay, for example, a charge on property. A charge is also a fee for service. Okay, all right, but anyway, I thought I'd make this video to kind of help y'all understand the importance of doing an affidavit. Verifying making sure your answers are in there. When you have an answer in there, it should be accompanying. It should be verified. Your answers should be verified. And I would even attach it. Say if you do a motion to dismiss or something like that. Damn, I had something in here where I was gonna mention about that. Say if you're doing like what was it? Let me see. I can't find it. I ain't gonna look for it because I said I'm gonna end the video. But I'm gonna end it. But anyway, if you have like a motion to dismiss for, after you've gotten all the what they call it, the discovery, all the evidence has been put on the table. Now you can motion for dismissal if there is no, if there's no evidence to support the claim that's brought against the straw man. So they won't, you know what I'm saying? So you got to make sure you have your answer, whatever it is you file in there, needs to be verified. So I will always verify my answers because otherwise it's not admissible evidence and it won't be, it's not good process. You got to do this shit properly. But anyway, I'm out of here. I'm going to go ahead and get it out of here. If you haven't liked and subscribed already, y'all, please go ahead and do that now. And I'll see y'all in the next video. And Emrose signing out.